Hey, everybody. So, do you know what indemnification means? If you're like any normal person, the answer is probably no. And if you don't, it could mean that someone else's mistake becomes your financial problem. Nearly all construction contracts contain indemnification clauses. The term means covering or saving one party to the contract from money damages or additional costs, usually caused by the other. The problem is that many indemnification clauses are far more broad than they need to be, and in fact, many are more broad than they're legally allowed to be. If you're a subcontractor, broad is bad. Broad means bigger chance that you wind up footing the bill for something that isn't your fault. Custom made contract forms prepared by some lawyers often aren't so reasonable because they're made to protect their clients without regard for you. Some of these contracts will require you to indemnify your customer, even if it's partially or fully responsible for the losses. This shouldn't be legal, and in fact, in Ohio, it isn't. Ohio has an anti-indemnity statute that specifically bars indemnity clauses that attempt to require one party to indemnify the other for its own negligence. But contracts with very broad indemnity clauses are still out there, and you could end up signing one if you don't know what to look for. Many widely used contracts, like the AIA A201 form, which is a very popular contract in construction, contains reasonable indemnity clauses that has limited indemnification for claims that arise out of the work, that are attributable to personal injury or property damage, and are caused by the negligence of the contractor or its subcontractors. Those are terms that a lot of people would agree are reasonable, and that's what contractors and subcontractors should seek in their agreements. And in fact, they should demand it. So don't just go ahead and sign whatever's put in front of you. It's important to be attentive to these types of things because it could save you a lot of money.